Hello, aspirants. I'm Advocate Pallavi Rai. I'm here to discuss with you about latest patent appeal. The students who are preparing for judicial services and the students who have already joined to work in High Court, they are aware with the fact what latest patent appeal is. Recently, you have heard also the news about latest patent appeal because Bihar APO vacancy was challenged and it was gone for latest patent appeal in Patna High Court. Many of you are aware, or some of you were not be aware from the fact what the latest patent appeal is. So today we will discuss about what the latest patent appeal is and where we can file it, within how many days we can file it, what the document we needed to file it, and what are the exceptions regarding this, and all the matter regarding we will discuss here. So latest patent appeal is an appeal by a petitioner against a decision of single bench judge to another bench, and that another bench judge can be of more than one. It can be of 2, 3, 5, 7 or more. This remedy is provided when High Court were created in India in 1865. So this is an appeal which is filed to challenge the decision of single bench, because single bench judge can be sometime unsound, can be wrong due to wrong fact as well as wrong law, as well as law, and we have option to file appeal in High Court or in Supreme Court. And to file an appeal in Supreme Court, we have substantial question of law. We have certificate of High Court to file an appeal in Supreme Court. And if we have opportunity to file in the same High Court, to file an appeal in the same High Court against the decision of single bench judge to another bench of more strength in the same High Court, we could file latest patent appeal in that High Court. That means if we have grievance from the decision of single bench judge to another single bench judge, we have option to file an appeal to another bench judge in the same High Court. And this remedy was provided when High Court were created in India in 1865. And the whole idea of this remedy is based on the principle that all men are fallible. Men can do wrong. We are human being. We can commit mistake. We can commit error. And judges are also a human being. They also can do wrong. They also can commit mistake. And the person who has not committed any error, who has not committed any wrong, is yet to be born. This is the remedy which is available in the court to the petitioner against the verdict of single judge of the High Court. Otherwise, remedy would lie with only in the Supreme Court. So this is the only remedy which is available in the court to the petitioner against the verdict of single judge of the same High Court. This is the only remedy. So if we have option to go to Supreme Court and to challenge that decision, we could not afford the fee of Supreme Court every time. Everybody could not afford the fee of Supreme Court, and cases with substantial question of law would only lie in the Supreme Court. And it is an intra-court appeal in the High Court and inter-court appeal in the Supreme Court, but both have a different rule in context of latest patent appeal. If you have option to file an appeal in the same High Court, you don't have to engage any advocate regarding another advocate regarding this. You have already an engaged advocate. He could file an appeal for you. He could do something in favor of you. So you don't have to overburden by any other engagement of advocate or something. You have already an option to file an appeal in the same High Court. and time limit for the intra-court appeal is maximum 30 days, and whereas inter-court appeal is a maximum of 90 days. Means if you want to file if you want to file a letters patent appeal in the same high court against the decision of single bench judge, you have the option to file an appeal within 30 days, and if you want to go to Supreme Court, you have to file within 90 days of the that decision. To file an appeal, the practitioner must make the court fee payment as stated in the schedule or a related information handbook, and the document needed to file an appeal are as follow: the copy of judgment and a decree appeal from, and certificate copy granted by the High Court, certificate copy of order granting the said certificate. So you have to you must have the document, these three documents: copy of judgment and decree appeal from, the certificate copy granted by the High Court, and certificate copy of order granting the said certificate. Next, we will discuss the provision of law, which is Article 226 of Indian Constitution and 227 of Indian Constitution. Article 226 empowers every High Court to order any authority, any person for or any government for the enforcement of any fundamental right or any legal right which is conferred by any law, by constitution, or for any other situation. And Article 227 empowers the High Court to deal with all other subordinate courts, councils comparable to its activities without bias to the oversimplification of the aforementioned provisions. Make and issue general standard. Make and issue general standard. Make and issue general standard and endorse structure for directing the training and procedure for other court, and further prescribe the structure in which book, sections and record will be kept by the officials of any other court. Means 227 empowers the High Court to deal with all other courts and councils, and to make the to make an issue general standard, to prescribe the structure regarding the in which book, section and record they all kept their record, in which book or section they kept their record. Now, what are the exceptions of letters patent appeal? So you could not file in letters patent appeal in this kind of, not file the letters patent appeal in some cases. There are also some exceptions, and you could not file in this type of cases. Letters patent appeal, first, the letters patent appeal is not maintainable in Arbitration Act. The 3-judge bench of High Court hold that letters patent appeal is not maintainable from an order passed under Section 8 of Arbitration Act. Only Section 37 of Arbitration Act applies to such appeal. What does here mean? That under Section 37, of Arbitration Act, you could appeal in the same High Court against the decision of single bench judge to the same High Court to another bench judge which is of more strength, which is of more judge. And additionally, provisions and judgment rendered under the Arbitration Act of 1940 can be relied upon while interpreting the provision of Arbitration Act 1996. In support of this, here we will discuss a case, Conros Steel Company Limited versus Lu Quinn Hong Kong Company Limited. A 3-judge bench of Bombay High Court noticed that an application under Section 8 of Arbitration Act filed, and this means that bar under section 37 of above mentioned act would apply to an appeal from order passed under section 8 of the act. Thus it was held that for order passed under section 8 of the act, the latest patent appeal is not maintainable. What does here means? Later patent appeal could not be filed in arbitration cases. You could not file in arbitration cases later patent appeal in the same high court. What does here means? That arbitration act only 37 empower.
So
under section 37,
there is no
you could
latest patent
file
appeal
such
in
appeal.
arbitration
But
cases.
second exception is latest
if
patent
you
appeal is
have,
not maintainable in criminal matters. If you are
but,
exercising criminal jurisdiction, no appeal could be lie against the decision of single bench judge of criminal proceeding in the same high court to another bench judge. Supreme Court of India decided that appeal to the division bench of High Court is not maintainable in any judgment or order passed by a single bench judge in criminal matters, whether the order has been passed under 226 Indian Article 226 of Indian Constitution or under 482 of Criminal Procedure Code. Latest patent appeal is a remedy given by both Supreme Court and High Court. This is provided to the party in the instance where he or she is not satisfied with the decision of the court.